The Democratic Alliance has filed papers in the North Gauteng High Court seeking a declaratory order for government to arrest Russian President Vladimir Putin if he arrives in South Africa for the BRICS Summit in August. This after DIRCO requested diplomatic immunities and privileges for the summit, and the ministerial leg, a standard move for all international gatherings in South Africa. DIRCO has clarified that the immunities do not override any existing international arrest warrants. The International Criminal Court issued a warrant for Putin over alleged war crimes in Ukraine. South Africa, which is a signatory to the Rome Statute, has adopted a non-partisan stance on the Ukraine war. President Putin is expected to attend the August gathering.
We're talking about the fact that this meeting has now been gazetted and the immunity has now been recognized in domestic law. So that's just a normal process. But remember that immunity, the immunity that's referred to in that minute, that host country agreement, it's called, is essentially an instrument to recognize an immunity that already exists under international law.
So some are worried and say that why was it done now, given what is happening around the Russian president? I'm sure you've just heard even the Democratic Alliance saying that there is no basis in law for this. So how then do you begin to make it all make sense for us who are watching this unfold?
Look, this becomes controversial because of the BRICS meeting and because there's an arrest warrant over Putin. But the reality is that this is a normal thing that happens for every multilateral meeting wherever it takes place. So it's not done for Putin. Now, obviously, it will cover him, but it's not done for him. It's just a normal thing. So if you think back, I mean, I'm just thinking wildly, in 2002, we hosted the World Summit on Sustainable Development. I wasn't working for the Department of International Relations and Cooperation. I was not an international law professor, but I know that there was a host country agreement because that's just the nature of things. Where a multilateral organization exists permanently, there is then a permanent host country agreement between the organization and the state in question. So it's just a normal thing. Now, of course, in this instance, it raises a number of controversies because of what's happening. But if there wasn't an arrest warrant, there would still be this host country agreement, and there would still be this minute and so on. So it's not a novel thing. That's the point I'm trying to make. And it's not because there is an arrest warrant over Putin. It's just something that has to be done.
So, Prof, let's then explain to someone who is watching tonight, because we've seen some of these reports saying that, this does not override the arrest warrant that has been issued by the International Criminal Court. You seem to agree with that.
I think that's correct. I've said several times that the immunities are recognized also in the Rome Statute, and they're recognized in two different provisions, right? So the one provision concerns customary international law. This is not what's at issue here with respect to the minute. The minute, and to the extent that minute refers to a host country agreement, that's in a different provision. And for that would override the arrest warrant if the minute had come before the arrest warrant had been issued. But because it comes afterwards, it doesn't. Now, there still remains a legal question over the recognition of customary international law, which I think is debatable. As things stand, if you look at the jurisprudence, both the jurisprudence domestically in South Africa and also the jurisprudence of the International Criminal Court, it would seem that we don't recognize the immunity. But if you look at our jurisprudence, if you look at the South African jurisprudence, and in particular the Supreme Court of Appeal judgment of 2015, it would seem that we don't recognize the immunity, not because of the Rome Statute, but because of the manner in which we implemented the Rome Statute. So essentially what the Supreme Court of Appeal said in 2015 was, we recognize this immunity story that you, Foreign Affairs or Department of International Relations and Cooperation are coming with. But in the way in which you domesticated the Rome Statute, you domesticated in such a way that you didn't recognize immunity, and therefore, on the basis of your own legislation, and that's the Rome Statute Implementation Act, you can't hide behind immunity for not arresting a sitting head of state.
So could we see him being arrested then?
I mean, legally, I guess, but politically, I mean, I don't think that that's possible politically. I just have to be honest. I can't see that happening. But as a matter of law, I think unless the government is able to challenge successfully the purported request for a declaratory order by the Democratic Alliance, then I guess, as a matter of law, there would be an obligation to arrest him. But politics are a different matter.
Now, what happens then? Because remember what happened with, the president, Omar al-Bashir at the time.
I remember too well.
And a lot of people talking about it now. It ended up in the courts, and then it wasn't effected, and a lot of people still citing that to say that the court's decision was not respected. So what happens now if there could be a repeat of history?
I mean, let's take a couple of steps back. So in 2015, it wasn't so much that the court's decision wasn't respected. Remember, the court's decision came after Bashir had left. Yes. Right. So now, of course, there are arguments about yes, but there was, there were games being played. So say now you have this court injunction by the Democratic Alliance, and say it's successful, right? Yeah. So say the Democratic Alliance receives a declaratory order for that Mr. Putin must be arrested, and say that the government is not able to successfully challenge that request. Then, as a matter of law, when Mr. Putin lands, there would be an obligation to arrest him. Now, again, that's a law, and whether or not it happens, that's a different matter. If it doesn't happen, the question that would then arise is whether or not there has been a willful disregard of a judicial decision, and therefore contempt of court proceedings may take place. And Prof, some people have said, watching these particular developments unfold, have said that this has a lot to do with the fact that our foreign policy is non-aligned. We're still sticking by that decision and saying that we're not taking sides, but of course, talking about this particular issue. How much of this particular decision to be non-aligned is in the spotlight right now, given these particular decisions and what we've seen happen with Lady R, happen with all of this that has been going on in the public domain? Well, I mean, I'm not sure that the non-alignment issue, is really the issue, because even if we had been aligned, remember what. So if you're looking at this from a purely legal perspective, what we have at play here is you have at best a conflict of legal obligations. I mean, there's no question that under international law, Mr. Putin has immunity. There's absolutely no question that there's a customary international law obligation on South Africa to respect the immunity of heads of state. The Supreme Court of Appeal decision of 2015 made that clear. It looked for exceptions, it overturned practice, and it tried to find exceptions. It couldn't find any exceptions. So there's no question. But on the other hand, there is this arrest warrant, which itself, I guess, creates a legal obligation. So you have the conflict of these legal obligations. So whether you're aligned or not, that conflict would remain. So I don't think that the non-alignment issue is at the heart of this particular question.